But supplementary 11, item number 11, it should have come for motion, but the auction is at 11 o'clock. Can it be taken up as item 1, my lord? Otherwise also it should have come up for motion. It has come up for admission wrongly.
Yes, item 1.
May I please your lordship? Lordship, I beg to mention item number 10. Lordship might not like to take up this matter as honorable
number?
just 10.
Yes.
As-
Is it so?
As Honorable Justice A.D. Chaudhary had appeared in this matter.
Actually, can you let this matter be listed before any other bench without one of us vacated? So this is our number. Same is item 1.
1.
Item 1 also same. Yes.
Obliged to
What
lordship.
supply item one?
Item 11.
Yes.
My lord, the petitioner before your lordship has admittedly taken a loan and there is an outstanding amount standing against his name. My lord, while taking the loan, he has given few properties as a mortgage. The mortgage properties were divided into two broad categories. One is primary mortgage and the other is collateral
So
mortgage.
you want they should proceed with another property?
Yes.
That's not permissible. That's not permissible because the law itself says it is the discretion of the bank to decide which property they want to proceed with.
My lord, I also wish to rely on a judgment which says, my lord,
Hmm.
Supreme Court, which says that the purpose of realizing a loan is not to penalize the judgment debtor. If the loan can be realized from other properties, then residential plots or all properties should not be put to auction. Here is a case, my lord, where my other properties is squarely, it is covering the entire loan amount. Had it been a case where it falls short of the loan amount, I would have not prayed before your lordship. What I am saying.
Yes, Mr. Ganguly, what do you have to say?
I have taken instruction, my lord. In this case, the property that he is wanting to sell, my lord, he's wanting to put on auction. That is a factory. That's a leasehold property. We have put all the three properties, all three assets on auction. Now, my lord, if he has a bidder who is willing to participate in the auction, we have discussed it with him. He is free to do that. But to insist that one property should be put, the other, my lord, that is unheard of in law, my lord. That is
My
not
lord,
permissible.
Mr. Biswas, please understand. First of all, you are in a zone where the interference of the writ court is extremely minimal. There is a recent judgment of 1.5 months back, where the Supreme Court has again reiterated Satyavati Tandon and said that it's not been followed by the high courts. So ordinarily, we would dismiss this petition. But we wouldn't like to be very, very mechanical and technical. Your only way out is if you give an undertaking to sell your property and pay the amount, and that too within the same time frame. Otherwise, there is no other way.
my lord, I will definitely do it. There is what has fallen from your lordship. My lord will kindly see 2 pages, only 2 pages, my lord. My lord will kindly come to page number 48. Now, my lord, this is, sorry, page number 51. That is. Now, my lord will see the properties which are put to sale at page 52. My lord is there at page 52.
Yes.
Schedule 1, there are 3 properties, my lord will see. 1, 2, 3.
Yes.
Now they have fixed a reason, and now my lord will see the outstanding amount, 3 crore 97 lakh. Now my lord will see the reserve price which they have fixed for property 1, 2, and 3. My lord, the base price, it will be natural.
Mr. Biswas, you conclude your argument, we are dismissing your petition. You are not understanding what the court is saying. There is a categorical judgment coming 1.5 months back, asking the writ court not to interfere in these matters. So you argue for 10 minutes and in the next 5 minutes will dictate the judgment to this. You are arguing against the settled law. Why are you using the time of the court?
My lord,
Your only way out is to say that I am going to pay this amount in this fashion.
I am going to pay this amount, my lord.
Pay the amount.
My lord, the property number 2 that is insisting that should not be put to auction. Even if he sells that, my lord, that will only bring one, as the reserve price is 1 crore 17 lakhs. Outstanding is well in excess of 3 crores, my lord. If he has a bidder who is ready to pay, my lord, for this property more than 3 crores, the outstanding.
You will have to, your property is gone,
And
nothing.
my lord, I do not want to get into the law, my lord, just, my lord, the recent judgment of the Supreme Court in Selere versus Bafna case, 13(8), his right of redemption is gone, my lord. The moment the sale notice comes, he has the full opportunity, his right of redemption is extinguished.
My lord, I am not trying to stall this auction procedure.
You cannot, even if you try, you cannot.
No, my
The
lord,
REIT court will not stall the,
my
we are
lord,
not stalling the auction process.
my lord.
Let's make it very clear.
Property 1 and property 2, my lord will kindly, that is what I was trying to indicate. Property 1 and property 3, which I am not even agitating, my lord, that covers their price. That is what is my submission. If that
So
covers,
Go ahead
if
with
the-
the auction.
If the bidder comes, my lord, we'll
Wait
be
a minute,
very happy, my lord, to
listen
sell
to
the.
our order.
Yes, lordship,
Go ahead with the auction.
lordship.
We'll fix the matter on,
Lordship may take it up on Wednesday perhaps, or
no. We'll fix the matter on 21st of June, 21st of, go ahead with the auction,
lordship,
but don't confirm the sale.
lordship.
Who is in possession of the property?
They are in possession of the property,
Don't confirm, don't, nor disturb his position,
lordship.
subject to the condition that within 21st, he makes arrangements for payment of the
for
amount,
the balance amount.
for the balance.
Because they are at liberty to auction 1 and 3. And if there is anything balance, that also I'm undertaking, I'll pay it by other means, my lord. Within 7 days, I'll pay it. Because I know, my lord, 1 and 3 will cover the loan amount.
My learned friend is saying they are at liberty to auction. I am at liberty to auction all three, my lord, provided that, my lord, we will not confirm the sale in respect of the residential properties. The other two, of course, I have to confirm, otherwise, my lord, the matter is
Absolutely.
over.
All right,
That's
where is
not
the
even-
notice? Where is the notice?
Page 51.
Page 51. Other two, I'm not
Right,
agitating. also.
Mr. M. Biswas, learned counsel appearing. What do we do? Counsel for the REIT appellant. Also heard Mr. A. Ganguly, learned counsel appearing for the bank. The appellant herein had availed. Is it what, OD facility or loan?
Loan.
Loan from the bank to the tune of, you have not even mentioned what.
Yes,
the amount.
yes, my lord. The loan amount is 392.50 lakhs.
3 crore.
No, it is 3 crore 92 lakh
50,000
50,000.
in the year,
2022.
in the year 20,
22, 31/3/2022 to be precise, page 18, 1A.
31/3/2022. But due to failure on the part of the appellant to pay the installment, the loan account had become an NPA. Full stop. Subsequently, the bank had initiated proceedings under section 13(4) of the SARFAESI Act 2002 and by issuing the auction notice dated 6/5/2024 annexure 5, as many as 3 secured assets of the appellant has been put to auction sale, which is fixed today, that is give the date at 11 AM. Mr. Biswas submits that he is not disputing the claim of the bank, nor is he unwilling to pay the amount. However, according to the appellant, the auction sale of properties described in Schedule 1, Roman 1, Capital Roman 1, and Schedule Roman 3 of the auction notice would be sufficient to recover the amount, recover the entire amount by the bank. And therefore, there would be no necessity to put the residential properties described in Schedule Roman 2.
Well, there is no Roman.
Schedule is one only, my lord.
Schedule is one only.
Property number 2, my lord.
Page 52.
Page 52.
Schedule, property number 1 and property number 3 of the schedule. Mr. Biswas therefore submits that there would be no necessity for the bank to put the property number 2, Roman 2, which is residential property of the petitioner, of the appellant, to auction sale. Full stop. On such ground, the appellant is seeking a direction from this court, not appellant, petitioner. This will be all petitioner.
May I just, I'm sorry, but just to add one line. Already one property they have auctioned. From there, they have taken 88 lakhs.
Mr. Biswas therefore submits that the respondent bank be directed to first complete the auction process of property numbers 1 and 3, and only thereafter, if there is any balance amount due and payable, the bank be permitted to proceed in the auction sale of property number 2, That is the residential property. Full stop. Responding to the above, Mr. A. Ganguly, Learned Counsel for the bank has submitted that the bank would have to go ahead with the auction of all the three properties to recover the entire amount. Full stop. However, the respondent bank would have no objection if the writ petitioner brings its own bidder for any of the properties, including the property number 2. First up, having heard the learned counsel for both the sides, we are of the view that although the court is not inclined to interfere with the auction process, yes, yet considering the offer made by the learned counsel for the bank, the matter deserves some consideration. First up, as such, we direct that the bank may proceed with the auction sale of the properties mentioned in the schedule of the auction notice dated 6/5/2024, but shall not confirm the sale in respect of the property number Roman 2, which is the residential property of the petitioner, till the next date fixed. Office to list this matter again on 21st of June.
I'm sorry, my lord, it is not Roman 2, it is
English.
numerical, English,
English.
numerical 2, my lords.
Not Roman, English too.
All these are English. not-
All English.
Property number 2 of schedule 1, Roman 1. Page 52.
Page 52, my
Number
lord.
2 of schedule Roman 1. The property number 1, 2, 3 we also will have numerical of schedule 1. All the three properties are of schedule 1.
Yes,
Lordship, there's only one schedule of
In the
properties.
meantime, the parties would be at liberty to work out an amicable solution so as to amicable solution towards payment of the balance amount, if any, due to the bank from the writ petitioner, and appraise this court on the next date fixed. The list again on 21/6/2024 as a fixed item.
my lord, any date barring 21, my lord, any date barring 21.
20,
20, yes.
20. Double it.
I'm deeply obliged.
Lordship, here we have challenged the impugn order dated 8/5/2024. As per the learned,
notice there are two matters.
Lordship, here we want to still because Lordship,
Stay will not revive because the notices have been set aside.
no Lordship, here learned single judge has held-
Search and seizure procedure has been
yes, was
declared
set
to be
aside
legal.
and held that it should be preceded by notice under section 130.
Correct. So you want a stay so that during the pendency of the writ appeal, you can proceed with the search and seizure.
Yes, Lordship.
If you want it, then we'll pass an order rejecting it.
No, no,
Or we
Lordship.
can issue
No,
notice.
Lordship,
on
here
it.
the problem is this. The law is that we can make search. And initially search was made on the basis of authorization. Thereafter, notice under section 131A was issued. Initially, a respondent objected, but subsequently he cooperated with the department. Thereafter, he checked.
Mr. Kyle, what is the final relief you are seeking here?
No, Lordship, we said, Lordship, there are two aspects of the matter. One, search and seizure. Second, notice under whether notice can be issued under section 131. That Lordship, there is no Supreme Court judgment. There are different judgment of High Court, Lordship. But regarding search and seizure,
Mr. Kyle, the learned single judge held that the search and seizure procedure is illegal.
yes.
You want an interim order to state so that during the pendency of the appeal, you can proceed.
No,
with
Lordship
the
will not
search.
proceed, Lordship then may provide that not be a precedent for other cases.
Then we'll pass an order rejecting the prayer. If you
No,
are
Lordship,
pressing on
No,
it.
because Lordship,
Otherwise, we can issue a notice on the interim prayer also. Which do you want?
Lordship notice may be
You
issued.
can go to Supreme Court.
No, Lordship, ultimately the matter is definitely matter will go because there is
You are
no,
asking for an order which is unreasonable, Mr. Kyle.
no, Lordship,
When
that,
the learned single judge by a detailed judgment has set aside the procedure,
no, Lordship,
you want to revive it by an interim
no,
order.
Lordship, one thing, Lordship may please to come to page 230. Just I meant to point out, Lordship, I'm not arguing much, Lordship. Paragraph
230.
12, paragraph 12. Page 230.
Yes.
At the time of hearing the writ petition, the petitioner has confined his argument on the legality of validity of the notice issued under section 131A. And this was the specific argument of the landed counsel for the petition law. And this was not the argument of anybody, Lordship. Even then, Lordship, we filed a recent.
All right, you choose which you want, notice on interim or order
Lordship.
dealing with the interim.
Lordship, notice on interim. Notice on interim.
Heard Mr. S. and Standing Counsel IT Department appearing for the appellant. There is this writ appeal is directed against the judgment and order dated 8/5/2024, passed by the London Single Judge in WPC number
WPC number of 969/2021.
169/2021, allowing the writ petition. We have perused the grounds taken in the memo of issue notice returnable. When do you want? After vacation, immediate? Returnable on, we'll make it 17th July.
Lordship.
Appellant to take steps for service of notice upon the sole respondent by registered post within 3 days from today. Out on the prayer of interim relief. Subject to service of notice upon the sole respondent, the said prayer will be considered on the returnable date.
Lordship, regarding admission, Lordship is keeping.
No, we'll issue notice first,
Okay.
the others will come. Same order in the other matter?
Lordship, I only, that is IA, Lordship, for stay, separate IA for stay.
In the IA, you write, issue notice returnable on 17/7. Applicant to take steps for service of notice upon approval. We'll consider your prayer, let them come.
Lordship.
I've seen the judgment. We may actually finally
No,
discuss.
our anxiety, Lordship, the entire law has been reversed, Lordship. By impugned order, the entire law of such sense is there has been.
You have, that is your ground. Why do you want it to be sorted today itself?
No, Lordship, I'm just.
Let
making
them
pre-
come, we'll
Lordship.
hear and then pass an order.
Lordship.
Judicial proceedings has to
No,
confirm.
no,
some
Lordship.
standard. Yes,
This is an appeal by ONGC Marat against the impugned judgment dated 20.
what is the problem here? He's a physically disabled person.
No, that precisely is the problem. And,
You should notice at this stage.
we are praying for a stay of the judgment.
Let them respond and we'll consider your prayer.
What has happened is, the direction is to comply within 2 months. That 2 months will expire at the moment, immediately they will come up in contempt. Unless,
We'll see if they come up, you know how it is, but we'll give you a firm date, 17th July.
our only anxiety is that. And out and out with greatest respect, my lord, the judgment is
When is 2 months expiring?
on 24th. Next,
Right? And then we'll fix it on 24th. Issue notice 24th. Not listed.
they have appeared, my lord,
I have appealed.
on
Caveat.
caveat.
On caveat.
Heard Mr. I. Chaudhary and senior counsel assisted by Mr. V. K. Das, and counsel appearing for the appellants. Also heard.
I am as a
Mr.
caveat.
Purva,
Copy.
learned counsel appearing on behalf of the, how many respondents are there?
Two.
Both
One
the
is,
respondents.
is for health. I am
Respondent
for one.
One, on the strength of a caveat. Mr. G.
I'm for the
Purva,
my respondent.
Standing counsel health present on behalf of the respondent. We have perused the impugned
No,
judgment.
you are
and
not
order
some
passed by the London Civil Judge on
Achha.
what is the date of the judgment and order?
23/4.
On 23/4.
Page 136.
Issue notice returnable on 24th of June 2024. The parties are already represented. No formal notice is required to be sent in this case. The prayer for interim relief made by the appellants will be considered on the next date fixed. The respondents may in the meantime file counter to the prayer for interim relief, if so advised.
Lordship, please to fix,
24th of June.
oblige.
So, when police.
What is this? There is another matter of this. How can you file a writ petition in Axis Bank, private bank?
Lordship, sir, that I have narrated in paragraph number 2, Lordships,
Mr. Sharma, it's a private bank.
private bank,
How a
Lordship.
writ petition is maintainable? Check up the law.
Lordships, ma'am.
And your lordship, their 17 is also due.
Huh?
And they can file section 17 application before DRT also, because we have issued possession notice. That is at page number 63.
Before the DRT. You can approach the DRT against
Lordship.
section, under section
17.
17, against the 13(4) notice. is
Yes,
it?
your lordship.
And raise this plea, whatever you want to raise, otherwise the writ petition is not maintainable. The private bank, once there is an order of the tribunal, then maybe 227 will come into play, but not at this stage. You understood?
Lordships,
What do you want to do?
I will withdraw and I'll file the.
All right. What will you do? Mr. R. Sharma, learned counsel for the writ petitioner seeks leave of this court to withdraw the writ petition with liberty to approach the learned debt recovery tribunal by filing an appeal under section 17 of the Surface Act, is it?
Yes, your lordship.
Against the possession notice issued by the bank under section 13(4) of the Act of Surface Act with the date. Prayer allowed? No, before that you write Mr. M. Sharma and his counsel for the bank is present and does not have any objection to the prayer. In view of the above, the prayer for withdrawal is allowed with liberty as paid for. The petition stands at this point.
I'll do this.
May it please the Lord. In this case, they have filed the affidavit, Lordship, regarding the steps taken pursuant to filing of this PI, Lordship, and 2 cases have been registered, Lordship.
You've seen the affidavit.
Well, yes, Malad. The annexure 3 at page 144, Lordship will see, Malad.
Affidavit was filed on 7th of June.
The 7th of June.
You want to obtain instruction.
Lordship, I have obtained instructions, Lordship, cases have been filed, Lordship.
Now, Malad, the investigation is going on and the police has also given a report that after the receipt of the inquiry report from the DC, they have added some section in the at page 144.
Then
Now
what
the-
remains in this case?
Now the investigation will go on, Malad, and they let them
Alright, heard
do it,
Mr.
Malad.
Um, Bordoloi learned counsel appearing for the petition. Also for Mr. D. Nath learned senior government advocate Assam appearing for the state to submit that in terms of the order dated 29/5/2024, an affidavit on behalf of the respondent number 4 has been filed on 7/6/2024. The said affidavit is on record. In the PIL, the basic allegation is to the effect that there has been heavy misappropriation of government funds allocated for the purpose of construction of Assam urban water supply, construction of water supply scheme in the, is it Sipsagar and Jorad?
Sipsagar municipality and Amguri municipality.
Amguri
By the
municipality.
Sipsagar municipality and the Amguri municipality. Full stop.
Under the Sipsagar district.
Under Sipsagar district. Full stop. Taking note of the grievance. After that you write, it appears that after the institution of the PIL, an inquiry was conducted, whereafter the inquiry officer, Sri Subhajit Khaun, SCS, had submitted inquiry report dated 19/3/2024, recording findings of serious irregularities in utilization of the funds meant for implementation of these projects. First of all, situated thus, this court had made a query with the state respondents as to what action has been taken by the state pursuant to the inquiry report dated 19/3/2024. First of all, the response of the state is available in the form of the affidavit dated 7/6/2024, wherein the following statement has been made in para 6, page 120. Full stop. Quote it here. Full stop. From the above, it is clear that law has taken its own course and inquiry is proceeding in the matter in accordance with law. As such, this court is of the opinion that the purpose of instituting this PIL has been met and there is nothing further to be decided in this proceeding at this point of time. Mr. P. Bordoloi, learned counsel for the petitioner, and Mr. D. Nath, learned senior government advocate Assam, have also fairly agreed to the said proposition. In view of the above, we close this PIL with the hope and expectation that the authorities will proceed in the matter in accordance with law and bring it to a logical conclusion without undue delay.
Lordship.
Is there any IA in this? Is there any IA in this?
No,
No,
Lordship. Enquiry reports to Lordship. One is 19/3/2024. That may be added, Lordship.
and other is 26/2.
Both the same inquiry officer.
No,
Not different,
same
Lordship.
enquiry officer same, one for Amguri, one for other for Sipsagar.
Which is for Sipsagar?
Sipsagar is Lordship, page 128,
Give the date.
26/2/24 is Amguri,
Enquiry report dated 26/3/2000
26/2/24 is Amguri,
pertaining to Amguri municipality and
and 19/3/24 is Sipsagar.
19/3/24 pertaining to Sipsagar
Sipsagar.
municipality, submitted by Subhadip.
Same officer.
Yes. Yes, will be same. Yes.
Lordship.
Yes, my lord.
Oblige your Lordship.
Lordship.
Yes, what is it?
Yes, this is your lordship, my lord. My lord, the local public of Hauraganj area is referred to lordship, my lord. Here, my lord, the pursuant to the order of the honorable
Issue
court
notice
earlier,
requested, that's all.
my lord.
But Mr.
Malab-
Biketa, school, it's a matter of school, so we'll see.
Yes.
Mr. Biketa, I counsel for the petition. By filing this writ petition styled as public interest litigation, the petitioners have raised concern about the functioning of a school which is faced with several obstacles, including lack of proper infrastructure and approach road. Considering this subject matter involved in this petition, we are inclined to examine the matter. Issue notice returnable in 6 weeks since Mr. Who is appearing for whom?
4, 6 and 7. 4, 6 and 7.
4, 6 and 7.
4, 6 and
So
7.
1, 2, 3. We are asking who is 1 and 2. You are giving us an answer of 2 and 3. What is this?
For one I am appearing.
Mr. Dina,
Five also.
you give the list who is
One
two.
for five. One
And you can take it up. Step by register.
Oblige.
Immediately, Lordship. My lord, by this petition, my lord, the petitioner have challenged the impugn action of the deputy commissioner whereby,
Which school is a government school?
no, my lord, private school.
We dismiss it on the next day. You tell us how it is maintainable. We can do it today, but this, you want it to be done today
lord,
or?
My lord, the petitioners are aggrieved by the order because the whole academic environment of the
What
school
this?
is going to
It's a
be.
Private school, what jurisdiction the DC has?
My lord, the rules of 2006 apply and the resolution that he's challenging that the guardians are not being given a say. The very resolution says, the very order says that there will be 3 members from the guardians in the committee.
My
So
lord,
therefore, this PIL, my lord, I think is misconceived because it does not have, even have a statement saying
My
that
lord,
he's able to pay the
Counsel for the
My lord.
petitioner, Mr. D. Manudar, Standing Council,
education department.
Education Department, Assam, has raised strong objection as regards maintainability of this PIL. full stop. In view of the above and on the request of Mr. Sundar, this matter is directed to be listed again in the next week so as to allow the petitioner's counsel to examine the issue of maintainability and address this court.
In fact, earlier the petition on the same issue was filed before the single judge withdrawn because of no locus standi. Now it has
My
come up
lord,
as a PIL.
my lord, it is a PIL, my lord, because the
You want the
environment of the school has been polluted, my lord.
Next-
By this order, my lord,
Next week
impugn
you
order,
want-
my lord,
All right, next matter, please.
My lord, this is, I am praying only for notice, my lord.
So what is there in this case?
My lord, yes, I admit, my lord.
You decide on a date of dismissal. That's the only thing.
I
Give
admit,
you a convenient date of dismissal of the reader.
I admit, my lord. I admit, my lord. I admit, my lord, but
There's nothing in it. She has resigned and after long she has come, then a single judge has held against her. What is the scope of overturning it in a
my
appeal?
lord, so far as CCS rules, my lord, that
She has resigned. Her earlier job is gone.
that is true, my lord.
What do you want?
Only notice, my lord, at this stage.
My lord,
Notice returnable in 8 weeks. So it's up to the applicant. Miss A. Gayan, Linus CGC.
for all the respondents.
No formal notice. Extra copies of the memo. Only notice for Mr. Kalita,
Yes.
My lord,
not for the applicant.
my lord.
May it please your lordship. Factually, I may not have a case because
You
the
cannot
fact
have a case
no, no.
factually and under the law.
under the law, there is a conflict. That's what I'm pointing out. We filed the AP not for the extension part. My lord, in
There is a
WPC
power of extension.
1911 of 2024, this honorable court had made an observation. It's all that count that we are fighting. My lord. There'll be conflicting opinions by honorable judges. If I just point out,
We'll examine the matter.
absolutely, nothing more than that.
Third, Mr. Bunny, Learned Counsel appearing for the appellant. There is the judgment and order passed by the single judge. This appeal is against 35, 2024.
My lordship.
Judgment and order is 35, 2024 passed in WPC number 2816 of 2020. By referring to the impugned judgment, Mr. Banik supplies that the directions passed in the impugned judgment is not only contrary to the earlier decisions of this court, but the same also puts in place conflicting decisions of the
My lord.
coordinate bench, as
In
a result of
WPC.
which matter calls for deeper examination. Full stop. Upon perusal of the materials on record, we are of the prima facie opinion that the matter calls for examination. First of issue notice. After vacation,
Absolutely. So vacation.
18th of July 2024, since Mr. P. Sharma, Learned Standing Counsel, Fisheries Department also has appeared and accepted notice on behalf of respondent numbers 1 and 2, and Mr. D. K. Sharma, Learned Additional Senior Government Advocate Assam has appeared for respondent numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copies be furnished to the Learned Standing Counsel, requisited numbers, first to enable them to obtain instruction. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case. Is hereby provided that operation of the impugned judgment and order dated 35, 2024 shall remain suspended till the return of it.
Obliged.
Alright.